Welcome in, everybody. Before we get started, please like, subscribe, and hit the notification bell. You know, all the YouTubey things. Forget what you think you know about justice. Welcome to the Virtual Juror, where snark is reality, but evidence is royalty. Where at first we look at the FACS, or Facts and Conjecture Shared, before we get into the real stuff. Before we begin, we want to tell you that most of the videos seen here from the courtroom are from previous hearings. This update is strictly on documents filed with the court and a media interview given by the defense. In this installment of the Richins files, a high-stakes You've Met Your Maker prematurely case has officially descended into a true crime screenwriter's dream, a slew of motions, 12 of them, a defense team TV interview, and a ruling from the court. We give you update number 5. The defense has confidently declared that a witness has torpedoed the state's aggravated elimination charges, a now sober jailhouse drug dealer who insists he only sold OxyContin, not fentanyl, effectively deleting the prosecution's link to the alleged weapon. Of course, prosecutors made a quick "nah fam" declaration, dismissing the recantation as an unbelievable stunt from an unreliable, low-level street dealer, and argued that the mountain of evidence, motive, opportunity, and the inconveniently deceased husband is still substantial enough to secure a conviction. As both sides continue to trade passive-aggressive court filings over whether one side is knowingly concealing evidence and whether the other is engaging in a fishing expedition through the victim's family's finances, the only thing we can apparently count on is that this courtroom skirmish has become more about whose witnesses are on whose payroll and less about the alleged Moscow Mule eliminator. We're covering the filings in the order they were submitted to the court. Up first, the defense's motion to appoint counsel for witnesses. This procedural maneuver shows a sudden, profound procedural concern for the constitutional well-being of the state's witnesses, specifically those who admit to the alleged unlawful distribution of controlled substances. Therefore, the defense is formally requesting that the court assign independent lawyers to these witnesses, ostensibly to protect them from self-incrimination, but realistically to encourage them to plead the Fifth Amendment. By doing so, these witnesses would legally become unavailable, which opens a fascinating procedural door for the defense to potentially introduce other, more favorable out-of-court statements without the pesky inconvenience of cross-examination. From a strategic standpoint, the defense is playing a game of procedural 4D chess. By insisting that witnesses like RC and NC get lawyers, they are essentially trying to mute the state's live testimony under the guise of ethical benevolence. If the witnesses take the advice of their new counsel and stay silent, the prosecution loses its ability to present a dynamic narrative on the stand. The prosecution, naturally, views this as a wolf in sheep's clothing. They know the defense isn't losing sleep over the civil liberties of local drug pushers, but is instead trying to sabotage the state's case by stifling their witnesses. The judge, meanwhile, is stuck walking a tightrope. While ensuring witnesses understand their rights is standard judicial housekeeping, the court will likely be wary of the defense using this motion to manipulate witness availability. However, denying counsel to someone admitting to felonies on the stand is a reversible error waiting to happen, so the judge will probably grant this request to protect the record, even if they see right through the strategy. Second, the state's fourth amended information. This is the prosecution's shock and awe roadmap, formally charging Kouri with being an aggravated eliminator, attempted aggravated eliminator, seeing her as a sandwich and/or Moscow Mule poisoning enthusiast. She was also charged with multiple counts of insurance fraud and forgery. The state lays out its motive, means, and opportunity trilogy. Kouri was purportedly drowning in debt, owing over $1.8 million with a negative bank balance. Mistakenly thought she'd inherit the kingdom, living trust controlled by Eric's sister, and allegedly sourced fentanyl twice. The first for a dry run on Valentine's Day involving a sandwich, after which Eric broke out in hives, used his child's EpiPen, and told a friend, "I think my wife tried to poison me." Kouri later texted a friend that she was just fucking with him, and he never broke out in hives. The second, the final fatal fentanyl femme fatale, in which Kouri Richins died from an orally ingested dose of illicit fentanyl, approximately 5 times the lethal limit. The state is painting a scene of a black widow who tried to kill her husband with a hoagie, failed, and then succeeded with a cocktail weeks later. In examining the courtroom storytelling, the prosecution is locking in its narrative that financial ruin equals an elimination motive. They are betting the farm on the idea that financial pressure was the catalyst for the poisoning. The defense, on the other hand, views this as creative fiction. They are preparing to attack the financial narrative by claiming she was asset-rich, and will likely argue that the poison sandwich story is nothing more than hearsay gossip derived from a mild allergic reaction. The judge views this document as the boundary lines for the upcoming legal battle. It ensures the charges match the evidence presented at the preliminary hearing, and creates the playing field, though it doesn't necessarily score any points. Third, the defense's request for order compelling disclosure of exculpatory evidence. This is the defense clutching their pearls in mock horror, shocked that the prosecution didn't tell them that their star witness, RC, recanted his story. The defense claims the state has been sitting on this bombshell, where RC admitted he sold OxyContin, not fentanyl, since April 2025. They're accusing the prosecution of hiding evidence that effectively deletes the elimination weapon from the defendant's hand, and are demanding every scrap of paper, email, and sticky note related to RC's interviews. The defense is screaming Brady violation from the rooftops. To them, the state hiding a recantation regarding the specific drug used to eliminate the victim is grounds for an all-out war. They want to paint the prosecution as unethical cheats who care more about securing a conviction than seeking the truth. The prosecution, conversely, is collectively rolling their eyes, arguing that a junkie changing his story is not exculpatory. It's just a Tuesday. They'll argue that they don't have to hand over every mumbled contradiction from a witness they already know is shaky. The judge, however, generally hates discovery disputes almost as much as being overturned on appeal. If there is even a whiff that the state withheld evidence that contradicts their theory of the case, the judge will certainly order it turned over immediately to sanitize the record, regardless of whether the prosecutor thinks the witness is lying. All joking aside, this could be a serious issue, but it's easily remedied if everything is disclosed before the trial. Fourth, the defense's affidavits of RC. Because one affidavit apparently didn't pass muster, the defense filed 2 from jailhouse entrepreneur RC. The first affidavit is a highly inconvenient piece of sworn testimony from RC, currently residing in the Davis County Jail. RC is attempting to clean up his prior statements because detoxing in jail apparently made him very confused and out of it during his first interview. He claims that in a May 2023 interview with officers, he supposedly said he sold fentanyl to CL. Now that he's sober-ish, he remembers things with crystal clarity. He declares he only sold CL OxyContin 30 milligram pills, aka Roxy's or Roxy 30s, on 2 occasions at a Maverick in Draper in early 2022. He highlights that when prosecutors asked him about this previous statement, he told them he did not remember saying that, and that he had been detoxing during the interview. In what we'll call the OxyContin sequel, just in case his first affidavit about drug dealing wasn't sufficiently detailed, RC is back with a revised edition that provides a more robust defense of his non-fentanyl-related crimes. This document serves as the extended cut explanation for why he was so wrong in his original interview, effectively affirming that he simply couldn't have supplied the fatal fentanyl for 3 reasons. First, the fentanyl famine. RC specifies that in early 2022, the only drugs he had access to were Oxycontin, sourced from his own prescription, naturally. He contends he was not able to procure fentanyl and didn't even require a source for it until the end of 2022, well after the death in question. Second, the semantics of slang. He underscores a detailed argument about drug terminology, claiming that when CL asked for blues, he properly understood this to mean 30 milligram Oxycontin. He further claims that the term didn't regress into a synonym for fentanyl until late 2022, at least according to his memory of his knowledge. And third, the cleanliness check. The affidavit further clarifies his sobriety, professedly stating that while he recently relapsed, he had been clean for about 9 months before that, adding complex context to his claim that he was only high and confused when he purportedly told police he sold fentanyl. RC is giving his best attempt to evade the elimination adjacent charge, insisting that the deceased only received the good, old-fashioned prescription opioid from his network, not the instant lethal kind, and he has a surprisingly detailed timeline to prove it. Essentially, the drug dealer is now claiming he sold placebos. The defense is treating this as their golden ticket. If the link to the fentanyl is broken by the supplier himself, the state's chain of custody snaps. They're banking on the jury believing the now sober RC over detoxing RC. On the other hand, the prosecution is sharpening its knives to shred this witness on the stand. The point that RC is a career criminal who is changing his story to avoid the elimination adjacent charge, and that his sudden clarity of memory is convenient self-preservation. The judge should contend that this credibility issue is a matter for the jury to examine, not a legal issue for the bench to dismiss. After all, are they really going to believe the story of a suddenly clarified memory of a drug dealer and an apparent drug addict? Or will it even matter in the end? The affidavits are filed, but the judge won't dismiss the case based on them. Instead, he ensures RC will remain the main attraction for a very messy cross-examination. Fifth, the state's opposition to defendant's request for order compelling disclosure of exculpatory evidence. The state's filing is curt. We didn't hide anything because there was nothing to hide. They confirm they met with RC, but since they unilaterally decided his new story was garbage, they didn't feel the need to share it with the class, unless that meeting went drastically differently than RC reports. They attached affidavits of their own, essentially swearing that they performed their ethical duty. The state may be taking a hard line, if not risky stance, by saying the state possesses no exculpatory evidence from that meeting to provide the defense. They're effectively saying their witness is a liar. However, if this did in fact happen, the judge could slap the state on the wrist for acting as the judge and jury of the evidence before the trial even started. Sixth, the defense's reply to state's opposition of defendant's request for order compelling disclosure of exculpatory evidence. The defense's clapback is simple. We don't believe you. They argue that the state did not deny that RC changed his story. Instead, they determined that it was not exculpatory. The defense insists this was not the state's determination to make. And to be fair, if this is how things went down, Kouri's defense team may have a point. Since they clearly don't trust the prosecution as far as they can throw a motion to dismiss, they are demanding a standing order forcing the state to turn over anything that contradicts their case. By arguing that the state usurped the jury's role in determining credibility, they make a compelling procedural argument. the prosecution is now on the defensive, having to hope that the judge agrees that the recantation was so incredible it didn't warrant disclosure, a losing battle in most courts. The judge will likely side with the defense regarding the production of evidence, reasoning that it is safer to order the state to hand over notes than risk a mistrial later because the prosecution decided to keep secrets. Bottom line, recantations are viewed through a pretty skeptical lens, since they usually arise out of self-preservation, like avoiding jail time or serious charges. Ultimately, a jury will be instructed to weigh the credibility of all the evidence. They'll get to decide which version of the story to believe. 7th, the defendant's motion to reconsider bail and conditions of release. In a nutshell, the defense is saying, hey, remember how you kept me in jail because I supposedly used fentanyl from RC? Well, RC says I didn't, so let me out. They argue that the substantial evidence required to deny bail evaporated with RC's recantation, and insist that without this link, the state is left with nothing but speculation. Therefore, Kouri should be released to help prepare for her trial from the comfort of her own home, or whatever's left of her assets. Realistically, this is a Hail Mary pass. The defense is trying to leverage the recantation to get Kouri home, using logic that if the link to the drug is gone, the safety risk and the strength of the case are gone. The prosecution will counter that bail isn't based on one witness alone. They still have a dead body, the toxicology report, the financial motive, and the pre-death behavior. They'll argue she remains a danger or a flight risk, regardless of RC's memory. Feels a little weak in our less than legal opinion, but it's an aggressive long shot. The judge knows that bail revisions in elimination cases are rare and will look at the totality of the circumstances. Unless the judge believes the state's case entirely collapsed, which it hasn't, Kouri will be staying in custody. 8th, the state's opposition to defendant's motion to reconsider bail and conditions of release. The bottom line, the state argues that RC is a lying liar who lies, but only now. They contend his new story does not withstand modest scrutiny and portray him as an unreliable street dealer speculating about pills from years ago. They insist his original story was corroborated by the victim's death and that the jury can still convict based on the constellation of other evidence, even if RC is shaky. This is what threading a needle looks like. The prosecution is arguing that RC is reliable enough to support the initial charges, but unreliable when he helps the defense. They're pivoting to this circumstantial evidence, motive and opportunity, as the anchor for continued detention. The defense will focus on the hypocrisy of it all by showing the state is picking and choosing which version of the truth they like, based on whether it helps them win. Side note, let's not forget that typically in accidental overdose cases, evidence of such an accident is found, near or around the deceased. And while a recantation can weaken the case, in the brief research we've done, Utah courts generally look at the totality of the evidence. So if the court believes the other evidence continues to support the charge, see the toxicology report and the motive opportunity evidence, over the word of an admittedly unreliable witness, the bail motion will be denied. 9th, the defendant's reply to state's opposition to defendant's motion to reconsider bail and conditions of release, and request for hearing. Opening with a philosophical quote about the stubbornness of truth, the defense argues that the state's case for holding Kouri without bail has imploded, and that the prosecution is in denial. They're requesting an in-person hearing so the court can personally observe RC's testimony and demeanor, and presumably agree that the state's case is falling apart right in front of their eyes. The defense wants a mini-trial on bail. If they can get RC on the stand now, they get a preview of his testimony, and a chance to embarrass the state before the actual trial begins. This prosecution would like to avoid that altogether. They want to argue on the papers, because putting RC on the stand is a wild card they don't want to play yet. A hearing might be granted, just to assess the witness's credibility firsthand, but it's more likely the court will rule the credibility is an issue for the jury, not a bail hearing, and deny the request. 10th, the defense's motion to compel Kouri Richins Benson to comply with subpoena ducis tecum. This is a classic follow-the-money strategy. Unfortunately for the defense, Kouri Richins Benson is not the one facing trial here. Either way, the defense is moving to force Eric's sister to hand over the trust's financial records. They claim she is withholding documents, and they need to see exactly who is on the payroll, arguing that the sister is paying witnesses to testify against Kouri. They want to audit the Eric Richins Living Trust, as well as Katie's personal or business accounts, to find any financial inducement affecting witness credibility. The defense pleads that the general balance sheet Katie provided is useless. They state that public testimony already confirms at least 2 state's witnesses have also been paid employees of the trust, and they need to see who exactly is on the payroll, arguing these payments go directly to credibility and bias of state's witnesses. This is certainly casting a wide net to find bias. If witnesses are getting checks from the victim's family, that is gold for cross-examination. The prosecution and Katie view this as harassment and a fishing expedition, arguing that Kouri, the alleged eliminator, has no right to see the money she supposedly tried to steal. We do not envy the judge's need to weigh privacy versus confrontation rights. They'll probably order the disclosure of specific payments to witnesses, as this is relevant to bias, but deny the request for the entire financial history of the trust, deeming it unduly burdensome and an irrelevant invasion of privacy. 11th, the memorandum in opposition to motion to compel Kouri Richins Benson to comply with subpoena ducis tecum. Kouri Richins Benson, through her attorneys, returns fire with fire, calling the subpoena a carpet bomb. Her lawyers argue that Kouri is legally barred from seeing the trust. The request is overly broad, and the defense didn't even try to call them to resolve it first, the meet and confer requirement. They characterize the defense's request as a desperate attempt to seize sensitive information under the guise of looking for bias. Her lawyers argue that Kouri's suspected bias is not a free pass to seize sensitive information. Here are the 5 grounds they contend. First, it's no secret. If it were, it's one of the worst kept secrets in the world, that certain witnesses are her retained experts. One even readily testified to being paid. Second, she's not entitled. The Utah Trust Code and Eric's Trust Agreement specifically bar Kouri from seeing these financials. Eric's trust gave Katie sole and absolute discretion to provide limited or no information to beneficiaries. Third, it's overbroad. The defense's request is a carpet bomb, demanding every receipt, invoice, bank statement, and handwritten note, which is burdensome and irrelevant. Fourth, it's privileged. The request improperly demands privileged attorney bills and expert communications. And fifth, it's procedurally improper. The defense never even tried to meet and confer, i.e., call them or meet with them, to resolve the dispute before filing the motion, which violates court rules. Katie's team asks the court to deny the motion and sanction Kouri for the terribly overbroad and burdensome subpoena. Katie's counsel is protecting the castle. They argue that Kouri's elimination charges should not give her a backstage pass to the family finances she's accused of coveting, but this might end in a split ruling, depending on what the defense has or what it doesn't. The court may compel Katie to produce checks, invoices, etc. from the trust or Katie's personal accounts to the two witnesses who have already been identified as being paid by the trust, but deny the carpet bomb request for all bank statements and tax returns. Appropriate redactions should be made, of course. Further, it's possible for the defense to face sanctions here for failing to follow the meet and confer requirement, which appears to be part of Utah procedure. Basically, yeah, Kouri should be able to vet witness bias. It's a constitutional right, which would supersede general confidentiality of the trust, but not the right to be protected from an overly broad and burdensome subpoena. That said, the most likely thing to happen at this stage is for the judge to deny the motion, at least temporarily, based on the procedural failures to meet and confer. In essence, telling the attorneys to go talk like adults before bothering the court again. 12th, the defense's media interview. In a truly shocking development, Kouri's legal team got tired of the courtroom and decided to try its case in the court of public opinion. Her defense attorneys sat down for an exclusive interview, claiming an ethical duty to correct the false narratives that they accused the prosecution of happily letting run wild. According to them, here's the real story. First, the Moscow Mule Eliminator nickname is fake news. The defense team insists this sexy and fanciful story was just grabbed by the media because it sounded enticing. They claim the prosecution has never once in court or in filings alleged the fatal dose was delivered in a cocktail. In fact, they say the lead detective admitted under oath that he has no idea how Eric Richins ingested the fentanyl. Second, Kouri was secretly rich and wasn't in financial distress. They argue that this is misleading because the state's math utterly fails to include the huge piece of property she acquired right after his death, which apparently had enough equity to cover her debts. They scoff at this omission, comparing it to evaluating your net worth while leaving out your house. Incidentally, this is the property Kouri and Eric reportedly argued over, and was an unfinished mansion. Not quite sure how that equates to having enough equity to cover all her debts, but please continue. Third, the life insurance motive is poppycock. The idea that she was trying to cash in, they say, is also false. The only policy she took out was one of those $100,000 free life insurance mailers we all get from credit unions, which she sent in about a month before he died. All the other policies, and there were a lot of life insurance policies, were supposedly taken out by Eric himself. The lawyers add that for this family, an extra $100,000 was not really all that much. Fourth, she only Googled the lethal fentanyl dose after he died. The defense is most incensed about the reports that Kouri searched for lethal fentanyl doses before her husband's death. They state this is just not the case, and the court records prove she made those searches after the medical examiner told her that fentanyl was the cause of death, a search that, they argue, makes perfect sense for a grieving, confused widow. Ultimately, the lawyers claim they had to break their silence and come forward. They frame the prosecution's narrative as sexy fiction and claim an ethical duty to correct false narratives. They feel the prosecution has gotten personal, used unusual language in its filings, and has failed its duty to justice by not correcting this misinformation. They are deeply concerned that all these false media headlines have made it impossible for their distraught and heartbroken client to get a fair trial. When asked for comment, the county attorney's office gave the legal equivalent of a motion to strike for ridiculousness, stating they would address all matters through the legal process rather than in the media. Last but not least, we have the court's order from November 2025 regarding Giglio material. This is a clean sweep for the state regarding the knock and talk interview from 2023. The defense had hoped to prove ethical violations, implying the police knew Kouri had a lawyer and interviewed her anyway. The judge ruled that because she wasn't in custody, no handcuffs, and free to leave, and hadn't been charged yet, her rights were not violated. Furthermore, the judge reviewed the state's outside counsel notes in camera, or in his chambers, and ruled they were work product, containing nothing exculpatory. We can just hear the state saying, "See, we told you," meaning the defense does not get to see them. This is a significant loss for the defense, and a sigh of relief for the prosecution. The defense was hoping to get the statements thrown out, on a technicality, or find something dirty in the investigator's notes, but they hit a brick wall. The judge's ruling solidifies that the police tactics were lawful, ensuring that whatever Kouri said during that initial interview stays in evidence. The state avoids a Brady violation regarding the notes, and the case moves forward with the prosecution's investigative record intact. In sum, this case is turning into a procedural cage match over discovery and witness credibility. Encouraged by the recantation of a jailed drug dealer who now swears he only sold OxyContin and never fentanyl to anyone associated with this case, the defense is using this convenient reversal to demolish the prosecution's entire drug supply link. They're leveraging this exculpatory or not bombshell to demand Kouri's immediate release on bail and accuse the state of knowingly concealing evidence. Meanwhile, the state doubles down, dismissing their witness as an unreliable street-level hustler whose new story doesn't change the motive, opportunity, and death by fentanyl evidence. In the meantime, both sides are fighting over whether the victim's sister, Katie, has to turn over the trust financials in order to prove witness bias, and the defense has taken the fight to the media, effectively launching a public relations counteroffensive to reduce the sexy and false narratives surrounding the Moscow Mule and Kouri's alleged financial distress to rubble. And the court put its foot down, telling the defense to knock it off when requesting work product information they know they're not privy to. The main takeaway? The only certainty in this courtroom is a battle of words between the state and the defense. Kouri remains innocent until proven guilty, and her trial looks to be emerging over the horizon soon, unless the defense has another card up their sleeve we have yet to see. Well, that's all we have. So as always, love your family, love your pets, love your neighbors, and we'll see you next time.